All right, we're going to talk about the new red flag gun confiscation bill that was passed in Minnesota as part of the 2023 legislative session. It was part of Senate File 2909, and unlike a lot of other bills that get passed every legislative biennium, this one doesn't take effect in July or August. It takes effect in January. So the effective date on this is January 1st, 2024, and that's ostensibly to give the courts enough time to come up with their procedures for handling these types of orders. The purported purpose of this law is to disarm individuals who pose a significant danger of harm to themselves or others through an extreme risk protection order. Now, there's two types of orders that are applicable to this section. One is the temporary ex parte orders, and those are done on an emergency basis where the only one side is able to go to court, present their evidence, and if the court finds by a probable cause that the person poses a significant danger to themselves or others, they will issue an order. Now, this is all done without the accused knowing that an accusation has been levied against them or being present to offer a counter narrative to what's being pushed against them. The other option is a with notice and hearing. These are called final orders. After a notice and hearing is there, the accused is there, able to offer their side of the story, and the judge will issue an order. The final notice and hearing order, it can be issued for up to 1 year, disarming the individual, and it can be indefinitely renewed. So who can apply for these orders? Law enforcement, county attorneys, mental health professionals through law enforcement can identify somebody who's a risk to themselves or others, contact law enforcement, and then law enforcement would begin these proceedings. And then a family or household member, as the law says. Family or household member is a parent, a child, anybody related by blood, anybody who resides with you, or anybody with whom you've ever had a significant, quote, romantic or sexual relationship, end quote. Anybody who meets those criteria are able to get an extreme risk order, including the emergency orders. So after a petition is filed, the court will schedule a hearing where both the petitioner and the respondent can present their case. For a normal order, the regular emergent extreme risk order, this would happen with notice and hearing, and both sides come to the court and offer their side, and then the judge will make the determination if the order should be issued and how long it can be issued, up to 1 year. If the court finds that there is evidence that the person poses a danger to themselves or others, if they're armed, the order can extend for up to 1 year, causing the person to be disarmed. They then from there have 24 hours to surrender their firearms to a federally licensed dealer or to law enforcement. The other side of this is the extreme risk order. The extreme risk order is issued, again, without the other party being present, and then a search warrant is issued to law enforcement to go and execute on the home, to enter the home and seize any firearms that are there. The respondent can submit a written request to have a order terminated. So after an order is issued, a respondent, who's the person who's the subject of the order, can request the order to be terminated. At that hearing, they have to prove by clear and convincing evidence, so not just the probable cause needed to issue the order. If they want to terminate the order, they have to prove by clear and convincing evidence that they are not a danger to themselves or others. So you have to prove that a danger to self or others doesn't exist. That's the standard that's laid out in this law. You have to try to prove that something doesn't exist, not the other way around. If you do violate these orders, you are guilty of a misdemeanor, and you also lose your firearms rights for 5 years. So it's very stiff penalties. Somebody who makes a false statement in order to obtain an order is guilty of a gross misdemeanor, but the law says that you have to prove that they knew that the information was false when they issued the order. That's a very difficult burden to prove somebody's personal knowledge. If they could just say that, well, I thought that they had these guns, or that they were a risk, or I sincerely believe that they made this threat, whatever the case may be, you wouldn't meet that burden that would trigger that. So ostensibly this means that there's really essentially no penalty for somebody who makes a false statement unless you can provide evidence that they knew that the information they were providing is false. And if it's just your word versus theirs, that's not enough to prove that it's that the information that they provided to the court was false. That's just he said, she said. That's not evidence of anything. And then, interestingly, the bill provides liability protection to law enforcement officers, civil and criminal liability for any damages that happen in the execution of an order. So if they injure somebody, if they shoot your dog, if they break your doors down, whatever, they have complete immunity from any liability related to that. They also have immunity from storing from damage caused of storing firearms. So if they put your firearm in a locker, they don't grease it up, they don't put any oil on it, anything like that. And by the time you get it back, it's just a rusted pile of metal. You have no compensation, no recourse for that. And also one of the common questions that we get asked on this is, well, do I get a lawyer? No, this is a civil process, not like a criminal process. So you do not get an attorney. You do not get attorney's fees. It is all up to you to provide for your defense against these potentially frivolous accusations. And then another question we get is, can you sue about these? Can the Gun Owners Caucus sue for about this? Again, much like the universal background check law, there has not been a direct facial challenge to the validity of the red flag order. So what we need is much like what happened in New York. We need a person who has issued an order and that in a way that violates their due process rights and it violates their constitutional rights. Then we have a cause of action to go and seek legal remedy. So if you are somebody who is subject to an order that's issued maliciously, falsely, or in a way that violates your due process rights, please do reach out to us, and we would love to talk to you about challenging this law in court. But at least at face value, until somebody is damaged, we don't have what's called a cause of action or standing, it's sometimes referred to, in order to bring this case to court. We really need to wait until somebody's harmed by it in order to bring a strong challenge forward. So hope that helps. If you do have any questions, concerns, comments, do feel free to drop us a line, contact@gunowners.mn, and we'll be happy to help you out.